everyone, welcome to Module 6, and at this point we're moving on to the next phase of the legal research subject. The first set of weeks was the preparatory groundwork, and we did that in quite a lot of detail because it's very, very important in terms of building the foundations of a project, managing the time, planning and all the rest of it. But for the next 4 weeks we're going to look at research sources in detail. And we're going to look at ones that you've seen before in a lot of depth. We're going to look at legislation and case law. And we are also going to look at theory and data, which are things that you may not have looked at in very much depth so far in your degree, but are things that are very important for researchers. Okay, so the first topic we're looking at is rules, and deliberately I haven't divided this into case law and legislation, because you'll find that while rules tend to align to legislation and regulation, and precedents tend to line up with case law, they're not exactly the same, and there's a substantial amount of overlap. So most of the time a rule will be written in a piece of legislation, most of the time a precedent will be explored in case law, but that is not necessarily the case. Sometimes you get a piece of case law that sets up a rule, and there are still some areas of common law where we go back to the common law for those rules. And also there are times in which precedents are set in legislation, where an Act of Parliament will say, here are some example situations of where the law may be applied, and here is how they are applied. They'll say, here is the rule, and for the purposes of interpretation, these are some of the situations in which we'll apply. And you see that quite often in definitions, where they say, you know, this is the Dangerous Dogs Act. A dangerous dog or a dog is defined in the following ways. It includes this, this, and this. It does not include this, this, and this. And those definition sections work in much the same way the precedents work. They look at the broad abstract rules that are set up as rules, and they fill in the details, and they say, well, here are some situations in which it's applied, and this is the way in which we should apply them. So that dance that we typically get between precedents, between legislation and precedents, where legislation sets the rules, precedents fills in the gaps, then legislation comes back and clarifies, and then precedents come in and fill in the gaps that are still there in the legislation. That to and fro can also occur in the common law, and it can occur through legislation as well. But most of the time the rule making in our system is done through creation of legislation and increasingly regulations. Regulations are becoming the dominant way in which we actually order our society for various reasons, and see admin law for all of that. But typically it is in legislation, through legislation, that we set rules, and precedents we don't get very much in the way of judicial lawmaking through case law anymore. Most of the time, the judges will set aside that role and say, well, that's really the role of Parliament. It's not us to make rules. And in fact, many of the times recently where we've seen controversy over the judges making law, for instance, the Mabo case, all they're doing is removing a previous era of case law that was wrong. So for all the stomping up and down of angry little feet over Mabo being the activist judges making law, all the judges were doing was looking at the terra nullius doctrine, which was created by judges, and saying that's a nonsense. We don't believe in that anymore. They were correcting one of the court's own mistakes. They weren't actually legislating. So most of the time, as I said, we don't see the common law anymore being very active in setting new rules. It was mainly responsive in terms of looking at ambiguity in legislation and filling in those gaps and saying, well, this is a situation that wasn't really envisaged under the legislation, it doesn't quite make sense, so this is how we would apply it, or this is something we're not quite sure of what the definition is, and we'll apply it in that way. One of the things that's a common experience for students who go through a normal legal education and they hit research for the first time, either in a subject like this or in professional practice, is the sudden realisation that case law does not matter very much in the real world of work. Where it does matter, it's very, very significant, but that's only in a very small number of cases. And many lawyers will go through their entire careers without having any significant connection with case law. Because most of what happens in the various different legal careers is all around the legislation and regulations. Occasionally, very occasionally, someone goes to court and may use a precedent, and very few people end up in a situation where they're in appeal courts where they're actually arguing those difficult, ambiguous areas. And that's quite a surprise for a lot of law students, because you've just spent a couple of years doing almost nothing but case law. And the law curriculum and the way it's been set up by the admission authorities, in that way, is very, very old-fashioned. The Priestley 11 that defined the way we have to conduct legal education was created in the 1980s. And it was created in an era where we still believed in the declaratory theory of law, which I'll come back to in a little while. So it was almost like it was created in another world. And that hasn't had an impact on legal education, because we're required to teach the way those standards set up the way in which we teach. And those standards put an awful lot of emphasis on case law. Now, I'm not knocking case law, and I think next week we're moving on to precedents, and I think having the skills in the case law area is very, very important. But occasionally when we hit research, people say, well, where are the cases? The cases are so important. The thing to realise is that cases in reality aren't very important outside of legal education. Legal education, we dwell on them to an almost obsessive level. And there are lots of reasons for that, but one of the reasons, just as a tangent, I guess, is that when law became an academic discipline in the early 20th century, it struggled to find its legitimacy. Where was its source of truth? You know, sociology source of truth came from great social theorists. Historians came from historical records. Well, where did law come from? Now, a lot of the people, original lawyers who set up those schools, and in fact, a lot of the lawyers in those days when they had tertiary qualifications, they're in divinity studies. So what they were used to is the declaration of the Word of God and the interpretation of the Word of God being their template or their approach for how they approach academic study. And they sort of transferred that approach. They weren't very willing to really look at something such as legislation as being the great source of the law, because that was made by Parliament, and many lawyers had a very cynical attitude around Parliament. So the progenitors of legal education looked to the common law as basically the closest thing that as lawyers we have as the Word of God, and judges are almost like bishops. Or the Chief Justice is like the Pope, receiving the word of the law and interpreting it. Now that seems slightly strange to modern ears, and in fact, even when I studied law, we were told that we were instructed under the declarative theory of law, that judges did not make decisions, judges had no discretion. What they did was they meditated on the law, they looked at the principles were there, and then the answer emerged to them. And if that doesn't sound like sort of mystic revelation, then nothing does. So yes, this sounds very strange, but this is the process of transition law has been through in my lifetime. It has come from this idea that the law is this sort of mystical force revealed through case law to this very realistic, pragmatic view we have now, where law is really what is created by Parliament. And this is where we come back to the theme of this week, is about rules. And that is the source of the law. The source of the law is the sovereignty of the people, not a process of mystic revelation where judges receive the word of the law through reading case law. But many of our principles of how we're required to teach, and the concepts we're required to teach, were formed in that earlier era where we were still under the sway of that old way of thinking. So there's a little bit of history of legal education chucked in there for you, and a little bit of an understanding, I think, hopefully, of why you spend a whole lot of your law degree just looking cases, and then finding out that actually cases aren't really all that important. However, before you get depressed about that, the skills you learn in interpreting and using cases are transferable. And there are times when you need to be able to do the analysis on cases. There are times where the legislation is incomplete. is inconsistent, is uncertain, and particularly in constitutional areas, it's hard to change the Constitution. You've been through all that. I won't go over the process of referendums again. So in those areas, the actual role of case law in understanding those topics is very, very important. And those skills are something that are useful at a high-end level to understand how common law works. And when we're teaching you, we're not just teaching you trade skills. It's not TAFE. We're not just teaching you how to work in the legal field. We're also teaching you about the ideology of law and the theory of law and the way in which law operates, and that's where cases become very important. But that's for next week. We'll get into that next week. For this week, we're going to focus on rules, and one thing that's important about understanding rules is seeing these rules as human-designed artifacts. And there's a sort of, I think a lot of people, when they're sort of overwhelmed by the law, they say, well, the law is the expression of justice. The law is the expression of these ideas of right and wrong. And you probably have realised by now, if you didn't realise before you started studying, that it's never that simple. And one of the important things to realise is that all laws are human-designed creations, and as such they're flawed. And one of the big problems we have with law and with creation of rules is that we have intuitive understandings of what we think is right and wrong. Now we often presume they're shared by everyone, and we're sometimes quite surprised when we hit other people who say, well, actually I don't agree entirely with your opinion. But we presume that these ideas of right and wrong. We then have to express them in language, and language is a very, very inexact tool. And just as a thought experiment, think about this. How would you create a law that encouraged people to be nice to each other? Have a go at it. Pause the video if you want to, or have a think about it over the next few days. If you had to write, a line of legislation that said, we, encourage people to be nice to each other, beyond that very broad, very abstract idea of being nice to each other, how do you actually do it? How do you quantify it? How do you define nice in a way that is consistent, that everyone can understand? How do we balance, the mens rea of what being nice is against, whether what you do is nice? Do we have to intend it to be nice? There are all these complications that. In that example, we realise how impossible it is to actually try and enshrine that in laws. If we take the converse idea where we're trying to prevent people from doing horrible things, which is what we mostly do in law, of course, then we are more comfortable with creating rules that say, don't do this, don't do that. But we still face the same problems in a more subtle way. That, we can say it's wrong to kill someone, but then there's the, well, what about this? What about that situation? What if it's a war? And what if it's assisted suicide? All sorts of very complicated questions. What if I'm defending myself? It's the only thing I can do. So every time you start with a nice simple principle of, your 10 Commandments style, don't do this, don't do that, you suddenly have all these exceptions that come in and situations of, how do you interpret in this context? And that is the problem of law, and that is the problem of defining rules. So you've been through a bit of this before with statutory interpretation, and statutory interpretation is really all about the problem of language, the problem of expressing something in a way which fulfills its purpose, the purpose rule, or the mischief rule, but also is sufficiently clear that its meaning is unambiguous, and that people can easily follow it, which I guess is the golden rule. And that is the core of this entire area. I think one of the ways to broaden your thinking about rules is to think about how rules operate in other circumstances, and the way in which rules codify complex relationships. So one good thing is to think about the rules of games or the rules of sport, the way in which the broad understanding of the way in which a particular sport operates becomes very, very technical when you have to figure out what the rules are for edge cases. Have a look at the number of sports, and I'm in Victoria, so AFL is the immediate thing that comes to mind, where there's the play on the field, there's the adjudication of the referee, and then there's everything that happens in the tribunal the week after, often about, you know, assaults and various forms of contact and what's legitimate and what's not legitimate within the sport. We take something like that's, you know, reasonably simple, like the rules of a game, the rules of sport, and we've got to add these layers and layers and layers of rules. And then, of course, what we do, and this is, you know, for next week, is then we add precedents on top of that. We have the rules as they're written down, and then we say, well, in this circumstance, we're going to apply it in this way. And then people can call back to those precedents and say, well, last week you said it was this. You know, the rules say this, you applied it in this way. Should you consistently apply it the way you applied it last week? So I think one way, often we get too tied up with thinking about legislation and laws in terms of what's right and what's wrong, what's legal and what's illegal. Think about something where the stakes are different, like a sport or a game. Think about the rules of Monopoly, the things that Monopoly doesn't cover, the things that cause all the fights in Monopoly that are not necessarily covered by the rules or are written in the rules and no one applies them or whatever. And you'll actually I think that helps you understand the interpretive problems and the interpretive issues in rule making and in legislation generally. And there's also a sense of meta engagement around those activities that I think is very fascinating. Even in a really simple game of backyard cricket, you will find there are rules lawyers. You know, when there are cases where you have standard agreements of, you know, what's a boundary and what's a six and what's whatever. You can see how much I understand about cricket. You know, is the fence on this side a six, but on this side you have to get it over the other side of the pool, right? And then when something happens, people respond to those rules differently, and some people go, yeah, let's okay, that's what we agreed, let's get on with the game. And then you'll find there are other people who get bogged down in the rules, and they want to stop the whole game and stop everyone's fun because they want to argue a particular point on the rules that they consider will benefit them or they think is the right result. So I think in these other rules activities, you also see the same sort of conduct and the same sort of attitude that influence people's behaviour around laws. And you see different people respond to laws in different ways, and they use the legal system in different ways. Some people negotiate their way through a situation. Often, you know, sometimes they take some disadvantage to themselves, but they get through the situation so they can go on to conduct their business and their lives. And other people get enmeshed in litigation and never ever leave the litigation system because they're so obsessed with the rules. So that's just a bit of a thought experiment to have you thinking about what you've already learnt in terms of statutory interpretation, but in that broader social context, and to understand that this is all connected up. Law doesn't sit by itself. That our own beliefs and attitudes around rules affect us all, and it affects you and me as well. Our decision to study law is based in our own background and our understanding of what rules are and how they work. The other thing leading on to next week again in terms of precedent, make sure you have a look at the material and the video this week on the bedtime rule, which is another example of a situation where I wanted to illustrate the relationship between rules and precedents without, using a very, very simple example. So have a look at that, and I think that will help you understand rules and precedents in a way that's different to just talking about Parliament and courts. All right, so the workshop this week focuses on legislation and regulations, and what you're going to do and what we'll do in class is look at a regulatory network map. Now, one of the things that's occurred in our legal system is that we rely more and more on legislation, as I mentioned, but more and more on regulations as well. And we now end up in a system where our networks of regulation are extremely complicated. So go back to the 1800s, there was this lovely sort of much simpler society and this ambition to create things like the criminal code. Let's put all the laws relating to crime in one place, so that if you want to know anything about crime, you pick up the criminal code and everything's there. Or of course we've got the Evidence Act as well, but kind of put those two together. We now live in a society where it becomes impossible to do that. All these regulatory systems are connected, and if you were to say, what is the law of the internet, for example, You've got laws on telecommunications, law on broadcasting, laws on content regulation, laws on network standards, laws on evidence and warrants. You've got laws on digital crime. You've got this amazing network of different laws that all connect together. And it's an incredible challenge to get on top of that material, because if you miss one piece of the puzzle, and each of those laws don't necessarily refer to each other, it's not like you read an area of the broadcasting standards laws and it says, oh, by the way, if you want to know the communications aspect of the internet, have a look at this act. Sometimes they do. Sometimes they are proactive enough to make those links for you, but often becoming an expert in the field is about understanding all those interconnections. So I'm not going to use the internet law as an example, because that will that is incredibly complicated. We'll look at an example related to our current research project, and what I think I'll do is have a look at the United Nations treaty, and look at how that becomes embedded in the local rules and how that connects to local laws, and that's going to be complicated enough for us. There's this activity, there's a reference to a chapter in a book I wrote a while ago on legal research, and that's on perusal for you to have a look at that chapter, where I go through some of the process of how to map out regulatory networks in different ways. Yes, it's mind mapping again, and everyone will be groaning, not another mind map, but it's a different sort of mind map, and it's a way of being able to try and understand those connections and conceptualize how these different regulatory standards work together. Because, you know, that is the world that we work in now. And occasionally someone comes along and there's a reform process, and we tidy everything up, and we try and we try to codify again, and we try to put those rules into one nice easy standard, but then it starts fragmenting again, and then we start creating all these different standards. So that's the complexity of where lawyering is really at. If the if case law wasn't complicated enough, we now exist in a world where we've got these interconnecting standards, and of course in a federal situation like Australia, you've got different jurisdictions as well, which complicates things enormously. And again, you then sometimes get these reform processes like the Uniform Evidence Acts and the Uniform Corporations Act, where we say enough is enough. We cannot continue with different rules in every different state jurisdiction and the federal jurisdiction. Let's make these work harmoniously. So it's this constant development of it's almost, you know, if you're aware of fractals, the way, you know, fractal growth and fractal change, you've got these networks of regulation. And it's not like the good old days of the 18th century, where you could say, here's the criminal code, and we're putting all the crimes in there. And if you need to know anything about crime, you go to the criminal code. We now end up in a situation where we have regulatory specialists who work in a field because it's too complicated to know everything. And I think this has also been another reason why there's been the decline in sort of the local suburban solicitor. There's lots of other reasons why, and a lot of that is to do with that sort of work a local solicitor does, drying up or going to other agencies. But there's also, I think, less of a role for the jack of all trades in law, and more of an emerging need for people who can get enmeshed in something like finance law, enmeshed in something like intellectual property law, and don't worry, don't let me worry you about, you know, that means the electives I choose at uni are very, very important, because this kind of expertise changes every few years. So don't think that means I have to dig into a particular field through my electives now, because that's where I want to be in my career, because what you study in these fields now is going to be entirely changed, and by the time you go into your career, and you're going to need to learn on the job as you go. But the skills you get from your law degree will give you the ability to build up that specialisation. But I think it's important to think in those terms, that really know the old-fashioned, you're a lawyer and you know the priestly 11 and you can do anything in law, is really disappearing, and the necessity of people who are entirely over, you know, personal securities, and what the law is, and where the difficult hotspots are, and what the developments are, and what all the key research in the field is really the way things are going. Okay, so we'll look through the process. There's some material in that text chapter on perusal. We'll go through the process of that mapping of regulatory networks. And again, something, no, you haven't done it before, I'm sure, but it's really important as a skill to going forward, just to be able to think about how can I quickly understand a field and how the pieces of it all work together and how these different rule systems actually interlock and interconnect, or the areas where they don't. And I think that's where a lot of work of lawyering is where we actually end up with gaps in the system. And lawyers are the ones who are able to go, well, how do we make that work? How do we fill those gaps? All right, so what else have we got in the materials for this week? The readings are basically a revision on statutory interpretation, which you've probably done to death. But it's probably worth skimming through that chapter again and being able to get to reacquaint yourself and to refamiliarise yourself with some of those core ideas in statutory interpretation. And do that also with a view to what you've learnt in admin law, with the importance of regulation as well. That admin law and statutory interpretation are two sides of the same coin, except that it used to be legislation was the important thing, and we had these little regulations on the edge which provided context, and we're now in a situation where the growth of regulation is enormous, and there's more work to be done in understanding those regulatory systems than any of the original legislation. All right, the equilibrium section this week, there's a great video on the Feynman technique, which is basically the way in which you can learn by teaching someone else a concept. And this is something which is empirically true and very important. And I think when you're doing study groups, I think this is a very powerful way of learning, being able to explain to someone. And you can do it with other students, and you can say, okay, everyone this week will explain one concept, and we'll sit down and we'll divide the concepts up and we'll explain them. It's a very, very powerful way to learn, is to get enough knowledge to explain to other people. But you can also do it by explaining it to other lay people who, parents, friends, anyone who can't run away from you fast enough, to be able to say, hey, I've got a concept of privity that I want to explain to you this week. And they'll say, yes, tell me about privity again. But being able to explain something that will, in a way that lay people can understand, is also very important. All right. So that's it for the introduction, which I think I've rambled on quite enough about rules. Next week we're going to look at precedents. And then we're going to have a look at what we do with data and how we use data. I can't make you a statistician in a week, but I can at least give you some pointers as to how to become, to actually talk in a way that sounds like you know what you're talking about with statistics. And we'll also look at theory, because theory is one of those things that often gets left out of the research context, and it's something that it seems to be, this abstract thing floating above everything else, looking down, casting judgment on everything. The theory is actually a really important tool as a researcher, because it gives you your beginning framework for understanding how you're going to evaluate things. And the different theory that you choose and the different toolkit that you use is going to give you a very different result and a very different process in the way in which you analyse a topic. So those things to look forward to. And then we run into the last 3 weeks, which is all about the completion and presentation of your research. So look forward to it. I'll see you in class this week.